Let's understand the ratio laid down by the Supreme Court by means of a case study. The case study that I'll be dealing with today relates to a movie called Dhoom 3. Dhoom 3 was a movie produced by Yash Raj Films, and so after the release of the movie, an allegation was made by a script writer that the movie was copied from the plaintiff's script. Let me give you a few background facts about this case. After the release of the movie, the plaintiff claimed to have seen Let me give you a few background facts about this case. After the release of the movie Dhoom 3, the plaintiff claimed to have gone and seen this movie and then found out that the movie seemed to have copied the script that the plaintiff had allegedly submitted to the defendant's studio way back in the year 2010. He then alleged that even though he had not heard from the defendant's production house for the past 3 years, it was quite clear that they had the plaintiff's script in mind while they were making this movie. The defendant also seemed to have copied substantial parts of the plaintiff's script. This was the case of the plaintiff. The Bombay High Court took up this case and decided on the motion of grant of an interim injunction against the release of the defendant's movies through television channels. The court found two things. Firstly, that the defendants did not have access to the plaintiff's work. The court reached this conclusion on the basis that the plaintiff's story regarding access was too far-fetched. Several things went against the plaintiff here. The court first found that the plaintiff did not include sufficient details regarding his visit to the defendant's offices when he filed the plaint, and it seemed to the court that his story was an afterthought. Secondly, the court also found that there was no substantial similarity between the plaintiff's work and the defendant's work. Here, the court relied on the R.G. Anand versus Deluxe Films case. What the court found that the similar parts between the plaintiff's work and the defendant's work were only ideas or sense faire. Let me give you some examples. The defendant movie also pertained to certain magical shows which were conducted and was a story of two brothers and a story of revenge. The court found that each of these were only ideas or sense faire, and even though both the plaintiff's work and the defendant's work had some similarities, these similarities could be traced back to other pre-existing works relating to magicians, involved twin brothers, and were stories of revenge. The court found that even though these similarities existed, they could be traced back to pre-existing movies or pre-existing works, and by now they can be considered to be sense faire, allowing anyone, including the defendant, to use these while making its movie. The court therefore came down hard on the plaintiff and said that the plaintiff did not make out any case of copyright infringement at all. Therefore, through this case study, I hope you understand that the bar of proving copyright infringement seems to be a high one, wherein the plaintiff must establish that actually the expression of the plaintiff's work has been copied by the defendant. Even though the underlying idea of the plaintiff's work might have been copied by the defendant, it would not amount to copyright infringement. Now let's move on to the doctrine of de minimis infringement. I mentioned in the context of the R.G. Anand versus Deluxe Films case that the defendant must have copied a material and substantial part of the plaintiff's work. In another case, the Delhi High Court applied this and said that the doctrine of de minimis infringement also applies to copyright, where the copying by the defendant was de minimis, then the acts of the defendant will not be considered to be copyright infringement. The court found 5 different tests which apply with respect to de minimis infringement. Firstly, the size and type of the harm, the cost of adjudication, the purpose of the violated legal obligation, the effect of the legal right on the parties, and the intent of the wrongdoer. Where the size and the type of the harm caused to the plaintiff is minimal, the court usually finds that this is not worth being considered copyright infringement and is too trivial for the court to look into. The other factors such as cost of adjudication, purpose of violated legal obligation, effect of the legal right on parties, and the intent of the wrongdoer are less relevant as compared to the first factor. This was all about the right to reproduce. Let's look at some of the other rights contained in section 14 of the Act. The second right that I'd like to deal with is the right to public performance and communication. The term communication to the public means making any work available for being seen or heard or otherwise enjoyed by the public directly or by any means of display or diffusion other than by issuing copies of such work, regardless of whether any member of the public actually sees, hears, or otherwise enjoys the work so made available. What does this mean? This means that an owner of a copyright has the exclusive right to communicate or perform the work in public. A very simple example would be that a person cannot show a cinematograph film in a movie theater without first taking the permission of the owner of the cinematograph film and paying appropriate royalty fees. Therefore, this is a very important right for the owner of a copyright wherein he is able to prevent the dissemination of his work to the public without enjoying certain economic benefits from that dissemination. In the terms of a literary work, the performance of the work by recitation, for instance, would also be prevented by a copyright owner unless he gives permission for the same. If a recitation is done without his permission, it would infringe his right of public performance of the work. The next set of rights available under section 14 is the right of adaptation, translation, and modification. The owner of a copyright not only has the right with respect to the work he creates, but also has the right to prevent others from making an adaptation of his work. Therefore, he has the right to prepare what we call derivative works. As the term suggests, this means the works which are derived from the original work. For instance, any alteration made to the work. Take for instance an abridgment of a book. An abridged version of a book is considered to be a derivative work, and therefore to prepare such an abridged version, the person preparing it must take the permission of the owner of the copyright in that literary work. Secondly, for instance, the author of a book has the exclusive right to adapt the book into a movie. You might be aware of the Harry Potter series of books. As you now know, most of these books have been converted into movies, and each time a person makes a movie out of these books, then in that case he has to go back to the author of the book, that is J.K. Rowling, and seek her permission to make a movie out of the book. Similarly, others have also relied on the underlying characters of the book and have come up with their own versions of different stories pertaining to those characters. Again, those books which rely on the same character as the Harry Potter books are considered as adaptations of the original books, and again permission must be taken from the owner of the copyright in those books for preparing such adaptations. For a broader definition of what adaptation means, you can have a look at section 2 clause A of the Copyright Act, where the term adaptation is specifically defined. Once you read it, you will understand that the term is defined quite broadly. The next set of rights is the right to issue copies. It is the right under the Copyright Act is a right to issue copies of the work to the public which are copies not already in circulation. Therefore, if the plaintiff puts a work into the public and it is already in circulation, he does not necessarily have the right to prevent further dissemination of that particular copy. However, he has the right to prevent others from issuing fresh copies of the work. This is the right to issue copies under section 14, and he cannot control the copies which are already in circulation. The next right available under section 14 is the right of sale or rental of copies of the work. This right is relevant for computer programs, cinematograph films and sound recordings. For instance, in respect of a computer program, a person is debarred from renting the CDs containing such computer programs, and this amounts to an infringement of copyright. Similarly, you may be aware of movie rental stores. Each of these movie rental stores must take permission from the owner of copyright before they can rent out a movie to the public. This is to ensure that the economic right available to the owner of copyright is not completely diminished by virtue of such practices such as hiring or renting out of such CDs containing computer programs or cinematograph films or sound recordings. These are the set of rights which are available to the owner of a copyright. Let's just go over them quickly once more. That is the right to reproduce, the right to issue copies, the right to publicly perform and communicate the work, the right to modify, adapt or translate the work, and the right of sale or rental of the work. Under section 14 of the Act, different kinds of rights are available for different kinds of work. For instance, literary, dramatic, artistic and musical works enjoy very wide rights under the Act. As opposed to this, cinematograph films and sound recordings enjoy fewer rights under the Act. Computer programs, in fact, enjoy very broad rights. They enjoy all the rights available to literary works as well as the right of sale and rental. At the end of the module, you will see a chart which I have prepared to show which rights are available for which kinds of work. Now let's summarize our learnings of today. We first studied the different kinds of works which are entitled to a copyright under section 13. We then studied the meaning of copyright and the different bundles of rights available under section 14 of the Act. We studied the right to reproduce, the right to issue copies, the right to publicly perform and communicate the work, the right of adaptation and translation, and the right of sale or rental. As regards the right to reproduce, we found there are two specific requirements: that the defendant must have copied the plaintiff's work and that there must be substantial similarity between the plaintiff's work and the defendant's work. The most common way of proving copying is by showing access to the plaintiff's work as well as a copying of the plaintiff's work by the defendant by showing similarity between the two works. As I mentioned, the level of copying must rise to the level of improper appropriation such that the copying of unprotected elements cannot be taken into account while considering whether the defendant has copied the plaintiff's work. Unprotected elements includes ideas and sense affair, and in this regard the R.G. Anand versus Deluxe Film case was discussed. Just to recapitulate, the test for copyright infringement is that if the reader, spectator or the viewer, having read or seen both the works, is clearly of the opinion and gets an unmistakable impression that the subsequent work appears to be a copy of the original, it is considered copyright infringement. To understand this test, we looked at the Dhoom 3 case study and found that the bar for proving copyright infringement appears to be a rather high one, since quite often courts find that what the defendant has taken is only the idea or the sense affair from the plaintiff's work. We then studied the test of de minimis infringement, and then we moved on to the right of public performance, right of adaptation, and the right to issue copies. And then we found that different kinds of rights are available for different kinds of work. Thank you.